All right, let's go on the record on cause number DC 1914668, Jason Wallace versus Peru Properties. Counsel, make your appearances.
Kurt Covington for the plaintiff, Jason Wallace.
Jason Charles Cherokee for the movement, the Omnibill defendants.
Okay, do you guys have, we have this motion for judicial determination that defendant substantially complied with this court's order. And so I guess the main issue is, did both sides, I guess, pay the full amount of the mediation fee? And there's some, I guess, question about that. Is that right?
Yes, Your Honor. Jason Charles Cherokee for the movement. The day after the court last heard this matter, on February 22nd, this court ordered that the defendants pay $4,000 to the arbitrator for the arbitration. And the day after that, on February 23rd in the morning, and that's attached as Exhibit A to defendant's motion, counsel for plaintiff Kurt Covington instructed the mediator that we just needed 1 day to try this. And if this court will see in Exhibit B, the Omnibill defendants remarked back, hey, this is great because I think we can get together and we can pull together and find the $2,000 to prepay for the arbitration. Payment was tendered on March the 5th, and I think that that's not disputed between Mr. Covington and I. We've looked at those other documents I filed as exhibits, a copy of an IOTA check, cashier's check order request, things like that. I don't think we dispute that we've paid $2,000, that the plaintiff has also paid $2,000. But since that time, the plaintiff is taking the position that by not paying $4,000, that the defendants are in breach of the court's order. And inasmuch as the arbitration is now supposed to be only 1 day and only supposed to cost $2,000 for that day, once the plaintiff made the designation when we were discussing potential trial dates, once the plaintiff made the instruction to the arbitrator that they were thinking it was just a 1 day trial or hearing, which is what we believed all along, we paid the $2,000 in good faith. If this court did find that we were acting in bad faith or that we were just extremely ignorant and we needed to pay another $2,000 within a certain period of time, as much as we can't afford or don't want that option, if we were ordered to do so, we would certainly take that option versus the alternative, which if plaintiff gets their way, on May the 19th, on our scheduled 1 day arbitration of the matter, there will only be an arbitration on the extent of damages and not liability. And so we are, as this court knows, this law firm generally doesn't file motions to show cause, motions for contempt, motions to compel. We're filing something because we felt like we had to. In as much as the arbitrator seems to think that this court would need to enter in some sort of order, either that we substantially complied with the order or that everything is okay. We think otherwise there's a great risk that either plaintiff will convince the arbitrator that even though we paid the same for 1 day arbitration, that somehow we're in default, et cetera. And so since the arbitrator suggested that we reach back out to the court, we're hoping that the court today finds that the defendants substantially complied. And when
let me ask this. So the arbitration fee is $2,000 a person for each side, or is it? I thought it was $2,000 for a half day.
$2,000 per side per day, Your Honor.
Okay, and the question is it 1 day or 2 day mediation or arbitration?
We all requested 1 day, Your Honor.
All right, Mr. Covington.
Yeah, thank you so much for being heard. Just a bit of the procedural background. We were ordered to arbitrate January 26th through 28th of 2021. The night before, we were informed by defendants counsel that they couldn't pay the fee. And so we weren't going to go. And that's when we came to this court seeking an order that they pay the fee so my client could have a stay in arbitration. The court agreed, and the court ordered that the $4,000 fee for a 2 day arbitration be paid within 10 days of the court's order, which is March 4th, 2021. We received word that March 5th, 2021, a half payment was made. So that did not comply with the court order. Now, there was talk between Mr. Sorochi and I, and he attaches some emails trying to block off a day in May. My client just wanted to be heard. We did not agree to a one-day hearing, but we tried to get at least a day on Mr. Gilbert's busy calendar. Mr. Gilbert did not agree, and he's the arbitrator, and that's his call. If I could share my screen, I will show you what he said.
Give me 1 second.
Sure.
Go ahead.
In Exhibit B to my motion, Mr. Gilbert said, the party said this case could not be done in one. The party said this case could be done in one day. However, the reason for the issue regarding the $4,000 payment for the last hearing was that there is no guarantee that it can be heard in one day, despite the best efforts of the parties. So while I agree to try to do this in a day, I'm not going to disregard the court order. So despite what any counsel was saying or what our intentions were, Mr. Gilbert said, we need $4,000.
Can I ask a question? Because to be honest, it's been a while since I practiced, so this is kind of a logistics on this thing. Let's say you finished in one day, would he refund the rest of the money? Is that how it works, or how does this work exactly?
It's typically how it would work. According to his terms and conditions, you forfeit it because that's a day he can't book something. But usually through courtesy, you get that money back. But regardless of the court here trying to look at what the parties intended, what the arbitrator intended, we think this is an issue we're in the wrong forum having this argument. We think this is within the arbitrator's realm to decide. This is an issue of procedural arbitrability, which under the law, time limits, notice, latches, estoppel, and others conditions precedent to an obligation to arbitrate, that's something the arbitrator decides. Now, whether there's an arbitration agreement, whether a dispute is within the scope of an arbitration agreement, goes to the court. So there's two reasons here we think Gilbert should decide it. Number one, he decided it, and he said, no, I need $4,000. And they did not schedule one day because Gilbert would not schedule one day. But the second reason is we don't even think Your Honor needs to make this decision because divining the intentions of counsel, looking through our emails, figuring out whether a half payment made a day late is going to suffice. We think that is for Mr. Gilbert to decide.
But I've already ordered $4,000 to be paid. Isn't that right?
Correct.
Okay. Okay. So I feel like I've already made a decision on this. The $4,000 need to be paid. It's up to Mr. Gilbert if he wants to refund part of that. So I'm not sure, Mr. Sirachi, I guess you want me to, what do you want me to do at this point?
Yes, Your Honor. At the last hearing, they made it seem as if they needed 2 days. And then after the hearing and before we knew the court's order, opposing counsel said, because we were still looking at arbitration dates either way, no matter how the court ruled last time. And so we received a May and a June date, and opposing counsel said, oh, we can do one day. That's the Exhibit A. I strongly disagree with opposing counsel that on the second day, when we couldn't even potentially be in default of the order signed on February 22nd, on the 23rd in the morning, that he was thinking, oh, they're already going to be in default. I'm only going to need 1 day to prove up damages. No, at that point, we're scheduling a hearing for the arbitration, and it's the plaintiff counsel that's saying that we only need 1 day for the arbitration. That's why we responded in Exhibit B soon after. Maybe that's 30 minutes later saying, hey, this is great. We think that we can pay the $2,000 for the 1 day and get this thing done. That's what our response was. So what did we do? We paid $2,000. Was the $2,000 on the 11th day for my law firm, IALTA? Yes. Opposing counsel and I think, agree on the other exhibits that I sent over, that as of 9 a.m. on the morning of the 5th.
This is my thoughts on this, which is if the parties agree that it needs to be 1 day and the arbitrator agrees that it needs to be 1 day and they agree to $2,000 and the arbitrator agrees to $2,000 and I need to correct my order, I have no problem with that. But if there's some type of dispute between whether or not we need 1 or 2 days, or the arbitrator feels like we need 2 days, I think it needs to stay the way it is. So Mr. Covington, are you disputing this? Are you saying that you want to try to do two, or you don't want me to change the order, or you do want me to change the order?
We do not want the order changed.
Okay.
There was some talk about trying to get it in a day. The arbitrator said no. And we needed 2 days because the arbitrator said we couldn't guarantee it'd be done in a day. So he's not going to do a day. So for that reason, the order is what it is.
And may I respond, Your Honor? The representation by Mr. Covington that the arbitrator either said, no, I need to reserve 2 days for this, or no, I need $4,000 from each side. None of that has been presented in emails, which are the only way in which we've been communicating with the arbitrator. I agree with opposing counsel with what he screen shared, and I can also screen share where the arbitrator thinks that if this court doesn't enter an order, then the 1-day arbitration is only going to be about damages and not liability. And hence, that's why with this order, we asked for the court to find that we substantially complied, or with that stuff in the alternative, that the court reconsider how it wanted to phrase that order, so that once the other side only requests 1 day, and once we agree to 1 day, that paying 1 day would not be seen as some sort of act of defiance with the court.
You have a record here, and I'll say it again. If the parties want to agree to a 1-day arbitration, and the arbitrator is okay with that, then the court is not going to find anyone in contempt because they've agreed to 1 day. But I'm not changing the order without an agreement from both parties.
When we're not here, just to be clear, we're not here as a movement moving for contempt against the other side.
No.
We are in arbitration. We're trying to go forward with Mr. Gilbert. Whatever the defendants do, they can do, but the facts are what they are, and we just need to get that before the arbitrator in that forum on that day. We just think plaintiff's motion needs to be denied. I'm sorry. We think the defendant's movement's motion needs to be denied.
I'm not going to do anything. I'm just going to, we have an order. The order is what it is, and it's going to stay that way. If the parties want to agree to something else, I'm perfectly okay with that. And you have a record. So anything else, guys?
Yes, Your Honor. Are you finding that the defendants at least substantially complied with the order with regards to payment for 1 day?
Absolutely not. Absolutely not. I don't find that, because the order says 4,000. The parties have not agreed to 2,000. If the parties want to agree, I have no problem with it. But if it's not an agreement, you need to stick with the original order. And 2,000 is not 4,000.
Okay, Your Honor. Is this curable between now and the May 19th deadline? Because if I tell my clients that we still have to pay another 2,000, they'd certainly do it versus have no defense. It's just with.
I would assume why is there a reason that wouldn't be under the order?
Okay, Your Honor. We agree. We tend to think like you think. We were just worried that the arbitrator might take no order, meaning that we shouldn't pay the other 2,000 to proceed. It's just. And I'll reconfer with opposing counsel as to whether it's 1 day or 2 days. And if he thinks it's 2 days, in spite of Exhibit A telling us 1 day, then we'll pay for the second day before the hearing date.
Yeah, I need to weigh in here. So this is the second default the defendants have made, and I don't know how many defaults the arbitrator is going to let them get. So we absolutely contest. They defaulted on the first hearing date. They've now defaulted under the second court's order. And this is the argument I'd make to the arbitrator, is that you've defaulted twice. We just have a hearing on damages now. They don't have unlimited time to make payment and delay Mr. Walls.
That is up to the arbitrator to decide. That is not my decision. So I'm not weighing in on that. If the arbitrator feels that I don't know what the deadlines are. I don't know. That's not my, I agree with Mr. Covington. That's not my area. And so if the arbitrator is willing to take another 2,000 and allow you to completely, was there some kind of deadline set about when you had to pay by?
The court's order. The first deadline, which was the first hearing, was 30 days before, and then we both got extensions on that. Plaintiff paid, defendants ended up not paying. The second deadline was set out by Your Honor in the court's order.
And he missed that deadline?
He paid a half payment a day late. So yes, Judge.
That's the 2,000 that we paid for the one day, Your Honor.
And so I think the arbitrator needs to determine, is that enough? Is he going to let him have more?
I mean, I'll just comment on what I think is, I hope the arbitrator does, but I'm not going to rule this way, is I hope the arbitrator, if Mr. Sorochi pays the rest promptly, that I hope the arbitrator will let this be decided on the merits so that we don't have this challenge on appeal, but that's up to the arbitrator. And I don't know what the arbitrator's, deadlines are, procedures. I'd rather this be decided on the merits, and I think Mr. Gilbert would too, but I understand the frustration when they defaulted the first time and then this time they haven't paid the full amount. But I also understand maybe there was a miscommunication. Obviously now, Mr. Sorochi, you know that they are not agreeing to this, and so you need to pay and see what Mr. Gilbert says. All right, guys?
Yes, Judge. Thank you.
Good luck.
All right. Thank you, Judge. Maybe